Welcome to AJM's Tax Dispute, hosted by AJM himself, Albertus Marais, and myself, Jackie Navaskachny. The purpose of this webinar is to provide an overview of the tax dispute resolution process, to take a look at some of the technical issues that taxpayers and practitioners are faced with in this process, and to identify and correct the correct course of action in those instances. Dealing with these technical issues correctly is of utmost importance because regardless of the strength of a taxpayer's merits, where the incorrect process is followed, this can be fatal to the process and prevent the taxpayer from even leaving the starting block. The point of departure is always the tax dispute resolution rules promulgated in terms of the Tax Administration Act. These rules regulate the entire process right from the request for reasons right up until the hearing of an appeal in the tax court. These rules are therefore an absolute staple to any tax practitioner dealing with tax disputes, as they not only set out the process to be followed, but also provide recourse where the process is not followed. A full set of the rules is publicly available, and we emphasize that it is crucial that you always make sure that you have access to the most recent and up-to-date version of the rules. If you're uncertain whether you do have access to those rules, you can send us an email and we will gladly share the latest version. Before I hand over to Albertus, I just want to encourage you to engage with us during the webinar by sending us questions, and we will answer them either immediately or at the end of the webinar. You can do this via the question and answer box at the bottom of your screen. Over to you, Albertus.
Thank you, Jackie. Colleagues, good morning. It's fantastic that we have so many of you participating in the session today, and I use the word participation advisedly because after all, I think that's what we want from this, is active participation and asking of questions and dealing with perhaps some interesting and novel matters that we see in practice. Jackie's mentioned it, but I'd like to re-emphasize this again. In our practice, where we deal predominantly with tax disputes, be it from when an additional assessment is raised up until the appeal process right through to the tax court, it is sometimes very sad to see, and it's sad to tell this to clients, that despite even the best merits in the world, if the form and the prescripts of the tax court rules, that is the dispute process, is not exactly followed, a taxpayer with even the best merits get disqualified. And obviously, due to the fact that we're dealing with tax matters, it very often leads to a very significant liability for taxpayers. And it is, of course, so that if that liability comes about because of a tax practitioner having not followed the rules, it is so that the tax practitioner may become liable for that tax liability as a result of the dispute process that is prescribed not having been followed. So for that reason, why we thought it's a good idea to talk through today to understand what the process really involves, what the steps of the matter entail, and that we can perhaps, in an humble fashion, educate perhaps tax practitioners on the correct way to go about dealing and prosecuting tax disputes, and to do so successfully. So what we're going to look at today, very briefly, our agenda, will involve looking at the dispute process broadly, what it involves. Jackie mentioned from the request for reasons through. After that, we'll briefly deal with some of the introductory issues in the rules, how to count time periods, the forms to be used, where to deliver the disputes to. After that, we'll look to the tax court process. Not the litigation process itself. One should understand, and this is why it's important to understand really the gravitas of the matter, is that the dispute rules are promulgated and known as the tax court rules. So right from the start, when a taxpayer receives an assessment and either requests reasons for it or objects to it, one is already busy dealing with the rules of the tax court. And those rules as Jackie said, are publicly available. If you don't have a copy of it, you're welcome to let us know and we'll send you a copy. But it's important to understand that we are in the tax court process. While we're not going to deal with the tax court itself today, we're dealing with the steps leading up to litigation. It is important to understand the seriousness of what we are busy with, even if simply objecting to an assessment. After we've dealt with that, we'll look at the burden of proof and when one is prosecuting a dispute, dealing with an objection, dealing with an appeal, what is it that a taxpayer would need to tell SARS and be able to prove to make his or her its point. But looking at the suspension of payment regime in the Tax Administration Act 164, that many of you no doubt will be aware of. And after that, we're getting into some detail in the dispute process itself. Going to look at a request for reasons. The taxpayer, after receiving an assessment, has the right, the ability to ask SARS, why have you given me the assessment? And we'll see that that is necessary in order to allow taxpayers to prepare a better objection. After that, of course, we'll deal with the objection stage of a dispute. And following that, if an objection is unsuccessful, the taxpayer has the right to appeal, which we're also going to deal with briefly. One can, of course, with the appeal stage, consider either to mediate first through the ADR process and then to litigate, or one can opt to litigate directly, be it in the tax board or the tax court. So those are the matters we'll deal with theoretically. We're going to finish off with some interesting scenarios that we see in practice, where perhaps SARS or tax practitioners misinterpret the rules. And when that happens, and there is a step or a communication that's being received that does not strictly fall into what the rules anticipate, how one deals with those cases then. Okay, so without further ado, let's have a look at the matter dealing, or broadly the dispute resolution process itself. The first issue relates to the matter of prescription. Now, colleagues, many of you will know that assessments become final after specific time has lapsed. These rules are contained in Section 99 of the Tax Administration Act. We refer to it very often as saying that an assessment has prescribed. It's become final just simply due to time having lapsed. For income tax purposes, an assessment becomes final after that assessment is 3 years old. For VAT and for pay-as-you-earn, where so-called self-assessments are issued by a taxpayer, that period is 5 years. Those periods, of course, needn't always apply, but it is important that taxpayers and practitioners are aware of those periods. And I say so because very often, when confronted with an objection or an appeal, that is the first defense that a taxpayer should be raising. And look, it is, of course, I want to emphasize here that it's entirely within the taxpayer's right to raise 5 arguments, 10 arguments, if you will, in the alternative as to why an assessment should not stand. But it is important to raise all of those, not to rely on simply one argument. So, for example, if I have excellent arguments on why an expense that I've incurred is deductible, but the assessment in question is also prescribed, I shouldn't simply rely on prescription in my objection in case I'm incorrect in relying on it. In the alternative, in our objections, we say the assessment as prescribed. In the alternative, the amount is deductible because of the following reasons, that it would have met all of the requirements in Section 11A. So taxpayers are entitled and able to raise more than one argument in an objection, and that is, of course, necessary. But dealing with prescription specifically, prescription is one that is often missed. And the first thing that you should be doing when receiving an additional assessment from SARS is to check the date on which that assessment has been issued, and to go back and to see which assessment has it altered, in respect of which assessment has this additional assessment being raised, and to see whether potentially the previous assessment has already prescribed or become final. There are instances, typically 3, where the prescription rules would not apply, and SARS raises them often, where the first is where there is non-disclosure of material facts by a taxpayer. Those cases, SARS says, and the Tax Administration Act says, that the commissioner was not placed in a position within the prescribed time period of 3 or 5 years to correctly assess because material facts were not disclosed to it. So that is the first basis on which there is the prescription rules are switched off. That's in section 99.2. The second basis is if there is fraud involved in the matter. The third one relates to a misrepresentation of facts. Now, of course, it is not simply as easy for SARS to allege that prescription does not apply. It must actually show that the misrepresentation or the fraud or the non-disclosure caused the inability to assess within the prescribed period. That's the first. And secondly, of course, it must be clear on what that misrepresentation, fraud, or non-disclosure involved. And thirdly, finally, SARS must also be able to prove that, in fact, fraud, misrepresentation, or non-disclosure occurred. So that's the first point that I'll make on the prescription of assessments. After one's received an assessment, very often we get asked to object to an assessment. And I tell the taxpayers very often, one shouldn't be immediately jumping into an objection. The first step is to request reasons for the assessment. Now, when one has a look at the tax dispute rules, and as we'll do in a moment, one will see that there is an option for a taxpayer to request reasons. So you're not obliged to request reasons. We very often encourage it for reasons we'll discuss later, but the taxpayer can, if it wants to request reasons, ask for reasons for the assessment, but must do so within 30 days of that assessment having been issued. If it opts not to request reasons or it's late to request reasons, which hopefully is not the case, then one has the option to object directly. I want to pause here at one matter very briefly, which is by far the most objections we said are lost because of the tax court rules not being observed. By far the biggest problem is days not being observed, the time periods. In other words, assessments are simply being picked up too late. And that is a massive risk, not only for taxpayers, but also for tax practitioners, because it means that if picked up too late, one is unable, with the best of merits, to dispute the matter, to do anything about it, meaning that the tax liability in question becomes final. And that is regardless of the assessment having prescribed or not. A taxpayer and a tax practitioner cannot dispute an assessment after these prescribed day periods have lapsed. So that is extremely important to note. And that is by far the most crucial message that I would like to get across today, is that the counting of days are so very important, and that starts with picking up assessments as early as possible. Okay, so that's the first matter. After one's requested reasons, a taxpayer can then wait and to receive its reasons, and once those reasons are received, one then has the ability to object to the assessment. And there's an 80-day period within which an objection must be lodged. It's not 80 days from when an assessment is issued when one has requested reasons. If you've requested reasons, then one waits for those reasons to be issued. And once those reasons are issued, one then objects to the assessment within 80 days of receiving those reasons. If one doesn't request reasons, then the objection is lodged within 80 days of the date of the assessment. Of course, once the objection has been lodged, SARS considers that objection, and it then has one of three potential recourses or outcomes. First is to say that the objection is not valid. That sometimes happens, sometimes lawfully, sometimes unlawfully. We'll get to that a bit later. The second is to disallow the assessment, or the objection rather, either wholly or in part. And the last one is, of course, to allow the objection in total. If the objection has been disallowed, either completely or in part, the taxpayer then has the ability to appeal the judgment or the outcome of the objection. The appeal process is often seen by many as an appeal again to SARS. In other words, almost as a second layer of an objection. That is not the case. After an objection has been unsuccessful, it means that SARS and the taxpayer knows that there is a problem, there is a dispute. They've tried to sort it out through the objection process. Once the objection process is unsuccessful and the objection is disallowed, and the taxpayer is still aggrieved by the assessment, then of course it's necessary to go to an independent third party that is objective. And that is what the appeal stage entails, in theory at least, I should say. Once an appeal is submitted, taxpayer then has the ability to either mediate through a mediator for the parties literally to get together around a table, or nowadays on a Teams meeting often, and for the taxpayer and the SARS auditor to engage with one another in a meeting and to discuss and to debate the issues at hand to see whether, verbally at least, the matter cannot be resolved. It is so that the rules make provision for an independent facilitator to be present at these meetings. Very often that's not the case. It's very often a SARS official that is present. Regardless, in my experience, the mediators don't fulfill that greater role. And very often it's simply a discussion, and which helps, is that a taxpayer engages with SARS directly in an informal manner to see whether the matter can't be sorted out, either through settling the matter or through the parties explaining and convincing one another of the position. If, however, the appeal through mediation is unsuccessful, that's not the end of the matter. It's simply a last case resort to try and avoid litigation. But in all cases, through an appeal, the taxpayer can say, I'm finished discussing these matters with SARS, there's no use in talking. Once lodging an appeal, it doesn't need to go to ADR. The ADR, or the mediation session, only takes place by agreement between the parties. The taxpayer is entirely within his or her rights to litigate the matter immediately, to say that I'm referring the matter for litigation, be it in the tax court or on the tax board directly without mediation. And there's no inference or negative connotation that a court draws to a taxpayer not wanting to mediate the matter. It's entirely within the taxpayer's right to say that there is no use in discussing matters further or discussing them at all when litigating. The alternative, of course, is if ADR or mediation has been preferred or indicated as the preferred option, then if mediation breaks down, the taxpayer then after that has the ability to still approach a tax board or tax court to litigate a matter. Okay. That in brief, the process. I am somewhat discouraged by the fact that we've had no questions yet. So, colleagues, again, I'd appreciate it if you can jump in at any stage or mention questions in the, make note of questions in the comments so that Jackie can raise them.
Albertus, we have actually received a few, but I think most of them are going to be covered by your next few topics. One question we have received is it possible to request condemnation for not requesting reasons within the 30-day period, or are you absolutely barred?
Yes, so there is a provision. If I could just, and again, go to the rules. And if we have a look at Rule 6, it makes provision for the fact of, therefore, and it's in the Rule 6.7, that an extension can be requested from SARS. And that is even after the fact for reasons to be requested. So it is possible. And of course, one needs to raise sufficient grounds for doing so. I would, for the reasons that we're going to discuss later, always encourage taxpayers to try and request reasons first before objecting. So if, for whatever reason, one is out of time to request reasons, I would encourage taxpayers to raise that request and to try and request reasons regardless. If we have a look at the rules, I remember very clearly when I started doing my articles, let's just say a long time ago, I was under the impression that an objection is submitted within 21 working days, because that's the SARS policy for within which information is to be submitted. And that's, of course, wrong. Anything that we do in tax law, and that's why tax law is such a fantastic field of law to practice in, anything we do in tax, we do because there is somewhere some stipulation that says we need to do it that way. And in this case, what regulates the dispute process is in the tax court rules. So it's important to understand that these day periods and the rest aren't simply made up by SARS or become practice over time. It is part of legislation. In this case, the legislation is specifically provided for in Section 103(1) of the Tax Administration Act that says the Minister of Finance, the Minister of Justice, consultation with one another, promulgates rules to regulate the tax court process. And those tax court rules are the ones that we are looking at today. We've stressed the importance of the formal requirements in the rules and why it is so important that they are very strictly reserved. One of the most important definitions, as I've said earlier, is the definition of what a day involves. Now, a day is a defined term. It's defined in the rules, and I've quoted that definition there in the slides. The first sentence there, it's in Rule 1, says a day means a business day as defined in Section 1 of the Act. Now, the Act there is also defined in the rules as the Tax Administration Act. So it says that to understand what a day is for the dispute resolution rules, we need to go to the business day definition in Section 1 of the Tax Administration Act. And that business day definition in Section 1 of the Tax Administration Act reads as saying it is any day, not a Saturday, Sunday, or a public holiday, which is unsurprising. And then, and this is often missed, for purposes of determining the days or a period allowed for complying with the provisions of Chapter 9. Chapter 9, what's that? Chapter 9 of the Tax Administration Act involves the tax dispute resolution provisions. Entails or involves this Section 103 and runs through the regulation of the tax board and the tax court process too. So it says that for purposes of tax disputes, a business day excludes the days between 16 December and 15 January, both days inclusive. In other words, if we arrive at the end of the year of the calendar year, that is, and I receive an assessment on the 1st of December, I need to, we said to one another under Rule 6, do a request for reasons within 30 business days. The correct way to calculate those business days would be to calculate all the business days from 1 December up to 15 December. That number we put aside, and again, I then look at how many further days, business days, I have after 16 January only, or from 16 January onwards. And in that way, getting to the 30-day or 30 business day period within which I need to lodge a request for reasons. Why this is important is very often this is missed, not necessarily by tax practitioners or taxpayers, but by SARS. So very often it is that we see in practice, particularly after the end of year holiday season, that the allegation is made that an objection is late or an appeal is late or a request for reasons has been submitted late because the taxpayer is ostensibly out of time for doing so. It is important then to point out to SARS in the correct manner that in fact these objections or whatever document has been submitted was not late, due to simply the fact that the day period needs to be calculated correctly. Now, colleagues, there is a different matter that we need to raise pertaining to timelines, and it's not only due to taxpayers not meeting deadlines, but very often in practice, we also see that SARS does not meet the prescribed timelines. And it is so that in terms of the tax court rules, there are certain prescribed time periods within which SARS needs to comply with the rules. And we've in this office 3-4 years ago had a rather successful matter against SARS where we've held SARS in default effectively, is to say that by virtue of not complying with the rules, SARS can no longer consider a dispute. It is simply kicked out of the process for want of complying with time periods. Now, the process to do that, of course, is how do we keep SARS to the timelines? It is so that if one wants to pursue a less aggressive approach, or dramatic approach perhaps, is to simply complain to SARS, to say that, look, I mean, you had 60 days within which to consider my objection and give me my outcome, you still have not done so. Please, can someone wake the relevant official up and have a look at my objection? But that is not really the prescribed process. It is also not that the tax ombud gets involved in these matters. It is specifically excluded from the tax ombud's mandate to get involved in this dispute resolution process. Now, the tax ombud deals with these matters reluctantly, and very often because it falls outside of its mandate, simply by saying that I'm not getting involved in any matter relating to a delay in prosecuting a dispute and getting involved in SARS not responding to a reasons request or an objection outcome or a request to conduct an ADR meeting. So what is the solution then? The solution is to go to Rule 56 of the tax court rules. So there is, for every problem, also in these rules, a solution that is being catered for. Now, what does Rule 56 say? Rule 56 of the tax court rules. And again, colleagues, I want to emphasize that we are from the start of this process involved with the tax court process. And therefore, Rule 56, where it deals with the rules here, it means that any of the tax dispute processes is covered by Rule 56. Rule 56 says, and let's read it together, it says that an application for default judgment in the event of non-compliance of rules. If a party, let's say SARS, has failed to comply with a period or an obligation prescribed under these rules, a period or an obligation, let's say, for example, SARS has not given us reasons, we've asked for reasons. The other party may, the taxpayer, deliver a notice to the defaulting party, to SARS, informing SARS of the intention of the taxpayer to apply to the tax court for a final order in the event that SARS fails to remedy the default within 15 days. Now, as I said, this is of course rather dramatic. Many taxpayers would often say that I do not immediately want to engage in the tax court process, and understandably so. It is often dramatic, stressful, and a costly affair. That being the case, in our experience, once you deliver such a notice to SARS, the tax litigation unit at SARS is quite sharp and awake, and they ensure that the relevant auditors react quite quickly. So this process, in our experience, has yielded extremely successful results. So that is something to consider. And then, of course, if SARS doesn't respond within the 15-day period, then the taxpayer has the option to go to the tax court and say, court, give us relief. We have no other option. We've tried to get a response from SARS, and to date we've not done so. So kick them out of the process, allow the appeal or the objection, whatever the dispute involves, simply on account of SARS not having complied with the rules. So this option is always open to taxpayers, if only to make the threat of bringing matters to finality. I would note one word of caution here, and that is to say that the Rule 56(1)A notice is a threat, is a warning shot to SARS to say that if you do not finalize this within 15 days, I'm going to court. Of course, one doesn't need to go to court. But very often this threat needs to be followed up with a real action from the taxpayer. And if one goes to court, the next step is to prepare a notice of motion, so-called, and a founding affidavit that needs to accompany it and be delivered to SARS and the tax court registrar. And these matters can only be dealt with by persons that are appropriately qualified to draft court documents, which often would be legal practitioners. So I wanted to raise it that it's I don't think as simple for a taxpayer by him or her itself to simply draft these notices and get them off to SARS. It may be that one needs to involve someone else to assist. Okay, but that is the mechanism to get SARS going in some of these long outstanding and old matters that do not seem to get resolved.
Albertus, 2 of our listeners have asked, how are these notices delivered?
So the notice really is a formal letter almost that is being drafted, and there is a prescribed address where these things need to be delivered to. It brings us perhaps quite conveniently into this Rule 2 that we have on the screen here. Rule 21C2 and 3 refers to the relevant addresses. So there is a public notice out from SARS prescribing addresses where certain documents and notices need to be delivered to. In the case, for example, of objections and appeals, these need to be submitted no longer by registered post or by email. They need to be submitted via e-filing. And perhaps we'll deal with some of the practical difficulties there. In the case of these tax court notices, the prescribed address is in that notice. If memory serves, it's Part F applications at sars.gov.za. Part F is the Part F of the rules that govern the Rule 56 process. And one also needs to serve or deliver such a document to the tax court registrar so that the case number can be opened and allocated to the matter. What makes this quite special and I think quite efficient is that the tax court serving process is significantly easier than serving documents if dealing with a high court matter. The tax court allows service of documents via email. So it really is as simple as drafting this notice, which is a 2-page document, and to email it to the tax court registrar and to this email address, Part F applications at sars.gov.za. Jackie, does that address it?
Yes, I think so.
Okay, excellent. Moving on to the forms and the delivery requirements. And these again are governed by the rules, and they're in the Rule 2 of the dispute resolution rules. As I said, nowadays, when one deals with a request for reasons or an objection or an appeal, those notices or documents need to be submitted via e-filing. So on e-filing, very typically, there is an RFR form. Not to be mistaken, I mean, one of the RFRs refers to a request for remission, which is when one deals with administrative non-compliance penalties if you paid your tax late or you've underestimated provisional tax. The other refers to the dispute provision that relates to the request for reasons. Now, very often we find that in practice, the relevant portal or link or whatever you will call it on e-filing is unavailable. And what does one do then? I've seen taxpayers often say that we were unable to submit a request for remission of a penalty, for example, so I've submitted it as an objection. You cannot do that. I've tried to submit an appeal, but there was only a link open for an objection. Also, you shouldn't be doing that. It is to follow the incorrect process then. What one should rather do is to make clear if the objection is accompanied by a letter, or to complete it in the relevant box of the form, if it is a simple matter and a small matter and one only relies on those forms, is to make it clear to say that this is an objection. I am unable to lodge an objection due to the e-filing constraints. I am therefore lodging it as on the notice of appeal form, but this is an objection. I am submitting it also to the SARS email address on this date, and this was the case number. I'm also going to submit it via an appointment with SARS. In other words, if e-filing makes it impossible for a person to comply with the rules and to follow the correct process, any means possible and as many means possible should be followed to show that one has truly attempted to comply with the rules, but that e-filing, this sometimes silly little system, precludes one from having followed the rules and disallowing one to complete the prescribed form in that particular instance. So this is also something that we see very often, that tax practitioners simply shrug and say, I was unable to follow the rules because of e-filing not allowing me to do so, so I just did something else. You cannot do anything else. It's very important to comply strictly with the rules. And if e-filing is the thing that prohibits one from doing so, one needs to ensure that you can demonstrate clearly that you've done everything possible to follow the rules. We're unable to do so, and that's the reason why you've submitted something in the manner that you have. Indicating, though, then, that this is not an appeal that I'm submitting, but an objection, or vice versa, or whatever the case may involve.
Albertus, someone asked, does the dispute process that we are discussing, does it apply across various forms of tax, or is it limited to income tax disputes?
That is a very good question and brings us to the next slide, Jackie, which is great. Thank you. What we are dealing with these tax disputes is anything that's capable of being objected to effectively. Now, very often, the most common example, obviously, is an assessment. If I've submitted a VAT return, and I receive an assessment from SARS 2 years from now saying I'm disallowing your inputs, that assessment is something that I can object to. Similarly, if I've included tax-exempt dividends in my tax return, I've been assessed on that basis that the dividends were exempt, yet SARS issues an additional assessment in a year's time saying, I'm not giving you the exemption on your dividends, here's an additional assessment, that is something that you can object to. Unsurprisingly, on these assessments, we also often have penalties. Those penalties can also be objected to if they are understatement penalties. Now, an understatement penalty is one that's linked to an understatement of tax. In other words, that a tax position adopted by a taxpayer is either incorrect or at least regarded as incorrect by SARS. Then an understatement penalty is levied. Very often, however, we also have administrative non-compliance penalties that are being levied. Those cannot be objected to, at least initially. An administrative non-compliance penalty, as mentioned earlier, typically involves a late payment penalty. If I paid my provisional tax or pay-as-you-earn late or VAT late, or in provisional tax, if I've underestimated my provisional tax obligation at year end, then that is also an example of an administrative non-compliance penalty. As I mentioned, the rules make it clear that you can only object to an assessment. A penalty itself has a specific, the administrative penalties themselves have specific sections in the Tax Administration Act that deal with how one has those penalties remitted. Those provisions are in section 217 of the Tax Administration Act. And only once a remission request has been disallowed by SARS, that is one of the decisions that one can object to. So there are a certain number of decisions in the Tax Act or tax acts that are also capable of being objected to. Those decisions, as we have here on the slide, involve if I was late to file an objection or an appeal, and SARS has said, sorry, I am kicking you out of the process on account of being late, regardless of you having tried to raise reasons for being late. That decision to treat an objection as late and not to regard the objection or not to regard the appeal, those decisions are capable of being disputed, objected to. The non-remission of admin penalties we mentioned, if I've submitted a request for remission, that request has been declined, that decision is something that I can then object and appeal to later. The last example would be the Income Tax Act in Section 3, subsection 4. This is a whole example of decisions that SARS takes in the administration of the tax acts that are also capable in and of itself as a decision that is capable of being objected and appealed against. Very importantly, and we've discussed now penalties of all sorts, we've discussed an income tax example, we've discussed a VAT example. The Tax Administration Act, and therefore the dispute resolution rules, relate to and cover all taxes levied under a so-called tax act. Now, a tax act is a defined term in the Tax Administration Act, and it specifically excludes the customs and excise legislation. In other words, VAT, estate duty, pay-as-you-earn, income tax, donations tax, dividends tax, all tax types that we have, all of them are capable of being disputed under the tax dispute rules, barring the only exception relates to the customs and excise legislation. Diesel rebates, for example. These are excluded from the tax court process. Doesn't fall within the tax court's jurisdiction. Therefore, when dealing with those types of disputes under customs and excise legislation, it has its own set of rules, comparable, coincidentally, to what we find in the tax court process, but importantly, a different process with different rules, and ultimately disputes that culminate not in a hearing in the tax court, if it goes that far, but in the high court rather, as something similar to a review application. What can one not object to? As we said, you can object to anything that is an assessment or certain decisions of SARS. If I have a suspension of payment application that I've submitted, we'll deal with them a bit later. It's been declined. That is not something that you can object to, because a suspension of payment application that's been disallowed doesn't culminate in an assessment. We've dealt with the administrative non-compliance penalties. They themselves have a separate process. If SARS has not issued an assessment in relation to a specific tax year, for example, then not issuing an assessment is also not something that you can object to. If, for example, we have these residency applications to say that I want to have my tax residency changed because I've immigrated a number of years ago, SARS disallows that. That is also not something that culminates in an assessment, determination of an amount of tax owing. So that's also not capable of being assessed. The same applies to VAT refunds, for example, not being paid. These are administrative actions of SARS that do not result directly in the determination of a tax liability, even if these decisions may affect it indirectly. So queries on this level, at least, one needs to follow a different route. Often it is so that taxpayers need to complain first, then go to the tax ombudsman, and if all of these so-called internal remedies have been exhausted, can a taxpayer then, if there really is nothing else left, approach the High Court for the appropriate relief?
Albertus, is it possible for a taxpayer to object against SARS's disallowance of a request for condonation?
It is. So that is one of the extension of timelines in dispute. The first sub-bullet under the heading of Section 105. The decision not to extend timelines for the submission of an objection or an appeal are specifically dealt with in Section 104 and 107 of the Tax Administration Act. We'll deal with the extension of timelines a bit later when we get to that part of the process. But it specifically provides for the fact that if SARS does not extend the time for lodging an objection or lodging an appeal, that a taxpayer can then object to that decision not to extend the time period for filing an objection or an appeal. Now that, of course, then becomes a dispute on its own. So one then objects against this decision not to consider an objection on account of being late. And if that objection against SARS's decision to treat another objection as late is disallowed, the taxpayer can appeal that outcome of the objection in the same way.
Albertus, and another question before you move on. Yes. In the case of an estimated assessment where the taxpayer filed a VAT 201 and failed to submit supporting documents, is the same dispute process followed?
That is so, absolutely. It is exactly the same. What it is it results in an assessment, and that assessment then is capable of being disputed. There are times where SARS issues an estimate assessment because the taxpayer has failed to submit a return, for example. In that case, one needs to submit a return first before being able to dispute matters. But that is in very rare circumstances. Once an estimate assessment is issued simply for want of providing supporting documents, those estimate assessments from SARS are also capable of being objected to. And again, Jackie, thank you for the question, because it leads us into the issue of burden of proof. And we'll deal with Section 102 briefly, which also deals with these estimate assessments. Colleagues, I think it is extremely important to know that we are being litigants when involved in tax disputes. We are in no lesser manner involved in litigation. Now, in any litigious matter involving questions of law, in other words, not interpreting statutes, there is a party that carries the burden of proof, that must prove something to SARS. Well, not to SARS, to the tax court at least. But initially, when dealing with an objection, SARS will take into account this burden of proof because it will be anticipating that this objection may go to court. So it will consider whether the taxpayer is able to prove its position. And this is extremely important, is that if one is going to be engaged in a dispute with SARS, the taxpayer and the tax practitioner carries the burden of proof. Means that the taxpayer can't simply say or state or allege a position. It must have proof to back that position up. And if one wants to thwart these disputes early on, it is important to have that proof available from the very early stage already when engaging with a SARS auditor, whether as part of an audit, a query, a review, or if as part of an objection or an appeal later. As you'll see here, Section 102(1) of the Tax Administration Act deals with the burden of proof. You'll see, colleagues, Section 102(1) lists a rather comprehensive list of situations and scenarios in which the burden of proof is always on the taxpayer. So that is very important to appreciate, is that very often I know we tend to blame SARS for not understanding and not wanting to believe and not taking trouble to get to know the facts. We must understand that SARS's mandate is to aggressively pursue tax collection. And there's nothing unfair about that. That is their statutory mandate. What we as taxpayers and tax practitioners need to be aware of is that we have a responsibility to prove to SARS and ultimately potentially an independent forum that tax collection is not warranted in this case because of certain facts existing. There are two examples where the burden of proof is not on the taxpayer. And that is in the first case where there is an estimate assessment being issued, as in the case now for the example, Jackie, that you've mentioned, dealing with VAT estimate assessments for want of supporting documents having been submitted. In that case, the burden of proof to show that an estimate is reasonable, in other words, that SARS hasn't simply sucked an amount from its thumb, that it is something that's backed onto reasonable assumptions or backed up by reasonable assumptions, the burden of proving that being the case is on SARS. The second one that is very important also to understand and that we deal with very often in practice are these understatement penalties. In those cases, SARS can simply say that it feels like levying a 50% penalty or a 10% penalty or 100% penalty. What SARS is obligated to do, and what it carries the burden of proof for, is to identify in that penalty table in Section 222, it needs to identify the relevant behavior of the taxpayer. I'm sorry, I think it's Section 223. It needs to identify the relevant behavior of the taxpayer, and it needs to be able to prove that that behavior has been present. And importantly, as the Perlish judgment told us a number of years in the Supreme Court of Appeal, that that behavior also caused the understatement in question. And only then, based on that behavior identified in that table, can SARS then levy a penalty. And SARS carries the burden of proof in relation to penalties to show, firstly, that the correct behavior of the taxpayer has been identified to link to the correct percentage for the penalty. And secondly, that the cause of the understatement in question being penalized was the behavior in question in that table. I'm now going to ask Jackie to talk us very briefly through Section 164 of the Tax Administration Act. What it involves briefly, colleagues, is you'll know that when a dispute is being lodged, the default rule, and that is because Section 164(2) tells us so, is that a taxpayer must immediately pay the tax debt in question, even though it is being disputed. It's one that we've colloquially started referring to in this country as the so-called pay now, argue later rule. Jackie.
Thanks, Albertus. So as Albertus mentioned, that is the default rule, but the Act also provides for a mechanism whereby a taxpayer can request that the tax debt be suspended pending the outcome of a dispute, where and this is important, this is the test of where a taxpayer can request suspension, where it intends to dispute the tax debt or where it has already disputed it. This means that the taxpayer can request suspension before it has formally submitted an objection, which is important because, as Albertus will explain, from the date of the assessment, a substantial period may lapse from then until the time that the taxpayer is required to submit an objection. And the fact this built-in double barrel test provides that during that period, the taxpayer can request the suspension while considering SARS's reasons and establishing whether it is going to submit a formal objection. So it essentially ensures that the taxpayer is protected against recovery steps during that initial period. In the request, the taxpayer or practitioner must satisfy SARS of the existence of certain factors that are set out in Section 164.3 of the Tax Admin Act. They are displayed there on the screen, and they include whether there is a risk of dissipation of the taxpayer's assets that would jeopardize SARS's recovery of the tax debt should the tax debt become due. So, in other words, should the taxpayer not be successful with its dispute. The second one is whether the taxpayer has a history of being tax compliant. The third one is whether fraud is prima facie involved in the origin of the dispute, whether payment will result in irreparable hardship to the taxpayer, and lastly, whether the taxpayer has tendered security for the tax debt. And importantly here is that when preparing a request for suspension of payment by the taxpayer or practitioner, it is very important that the taxpayer address each of the factors in detail. This isn't as simple as simply checking a box on e-filing or submitting a standardized or template request for suspension. Each factor needs to be addressed to ensure that enough information is placed before the senior SARS official considering the request. That being said, the factors are considered in conjunction with one another, which means that these should not be elevated to requirements. The SARS official will consider them, but if one does not count in the taxpayer's favor, it's not to say that the SARS official can or will decline the request. The overall effect is for SARS to weigh up the hardship that would result to the taxpayer if they are required to pay the amount upfront versus the prejudice to SARS if the taxpayer does not pay the amount upfront, pending the outcome of the dispute. And a question that we come across a lot in practice is, when does the suspension come into effect? And the answer is, fortunately, immediately. That is, from the day that SARS receives the request for suspension up until 10 business days after SARS issues its decision on the request, the suspension will be in place. What this means is, if it is approved, then the suspension will remain in place until the finalization of the dispute. And if it is declined, it will remain in place until 10 business days after that decision to decline the request, thereby just providing the taxpayer with time to make necessary arrangements to make the payment. And during that time, SARS may not take any recovery steps despite not yet taking a decision on the request. So the second factor is whether the taxpayer has a history of being tax compliant. The third one is where the fraud is prima facie involved in the origin of the dispute. Next is whether the payment will result in irreparable hardship to the taxpayer if it is required to make the payment upfront. And the last one is whether the taxpayer has tendered security for the tax debt. And it is vitally important that each of these factors are addressed in detail and properly in the request. It is not as simple as checking a box on e-filing or submitting a template. Each one needs to be addressed specifically for the taxpayer and his circumstances, just to ensure that enough information is placed before the senior SARS official so that he or she can consider the request properly before him or her and make a decision. That being said, these are specifically factors and should not be elevated to requirements, which is another issue that we will deal with. SARS often does elevate them to requirements, but they are to be considered by SARS in conjunction with one another, and where, for instance, one does not apply in the taxpayer's favor, it's not to say that a request for suspension will or can be declined. Ultimately, what SARS will do, or what they are required to do, is to draw a balance between the hardship that it will cause to the taxpayer to make the payment upfront before disputing, and the prejudice to SARS or the fiscus if the amount is not recovered. Albertus, do you want to take a break now, or can I finish up on when the suspension takes effect from?
No, I think let's finish up this slide first, and then I think we take a break.
Okay, perfect.
Jackie, I'm not sure, you'll probably get to it, but your comment that these factors all need to be addressed are very important. I know, colleagues, that very often when we receive an assessment, we get hot under the collar. But I've seen so often that the taxpayers in the form write in caps letters, this is unconstitutional and unfair, and SARS shouldn't be doing this. And those aren't factors in section 164.3.
Then the next question is, once you have submitted a request for suspension, when does it take effect? Because we get the question a lot in practice, where you have a taxpayer that now has this tax debt that they believe to be incorrect, and that they don't have the funds to settle. And they've submitted a request and they aren't hearing back from SARS, and they are obviously anticipating a demand and recovery steps at any second. The good news is that the suspension has effect immediately from the day that SARS receives the request until 10 business days after it issues its decision on that request. And this is a safety mechanism that operates in the taxpayer's favor, because if the request is approved, then the suspension will remain in place until the finalization of the dispute. If it is declined, then it will remain in place at least until 10 business days after that decision, thereby just providing the taxpayer with enough opportunity to gather the funds and make a plan until the amount needs to be paid. So during that time, from the day that SARS receives the request until the 10 days after the suspension has been declined, SARS is not allowed to take any recovery steps despite not yet having made a decision on the request. And what is important here is just to go back to Albertus's point about delivery, because the Act specifically states that the suspension will be in place from the date that SARS receives the request, which means that you need to ensure that effective delivery of the request has taken place for SARS to have received it and for the suspension to be in place. And for this reason, going back to the practical example that I mentioned earlier, it isn't necessary to follow up on SARS's decision, even though the taxpayer may be anxious for a confirmation of the approval of the request. You can assume that once it has been submitted and received by SARS, that there is a suspension in place until you receive the decision declining the request for suspension. Albertus, please jump in at any moment if you feel.
No, that's 100% right. It's one of those things that are often very curious to me, is that people tend to rush these applications, say that SARS is not getting back to me, and please follow up. And we're rushing SARS and pressuring them to deal with the application. One shouldn't do that. One simply shouldn't, because in the meantime, while SARS is considering it or otherwise just not doing anything about it, the debt is suspended. It's not due at that stage. So it is not something to be concerned of. I know that practically very often, despite these suspension applications going in, SARS is still taking recovery steps. And that is, of course, unlawful. There are other avenues through the tax ombud or through the complaints mechanism or the High Court that one addresses that, because that is unlawful action. But Section 164.6, as Jackie said, is extremely important and very clear, is that once you've submitted the application, SARS cannot do anything.
So we ended off with when a suspension of payment will take effect, and we said that it is immediately. And then the next point to note is Section 256 of the Tax Administration Act confirms that once a tax debt is suspended, either because SARS has not yet made a decision on the request for suspension, or because it has approved the request, the suspended tax debt cannot alone be the cause for a taxpayer's tax compliance status to be reflected as non-compliant. So the Act specifically provides for that, and we know that this is an issue in practice. Once the tax debt is suspended, it means that SARS cannot lawfully take steps to recover that debt from the taxpayer. And this includes a variety of things. For example, SARS cannot lawfully issue a letter of demand to the taxpayer. It cannot set refunds due to the taxpayer off against the suspended tax debt. And importantly, where this is the case, for example, with VAT refunds, and the SARS setting off the VAT refunds against a suspended tax debt effectively means that it is not releasing those refunds within the stipulated or prescribed period in terms of the VAT Act. And in that case, a taxpayer or their practitioner is entitled to request that interest be paid on those refunds from the date that it should have been released to the taxpayer. That's in terms of Section 45 of the VAT Act. But of course, SARS does take these steps unlawfully, and where these steps are taken, the taxpayer's recourse is to approach a court for relief. Albertus, one of the questions that we received is, how do we address the non-compliance issue with SARS?
So again, it is one of those terribly irritating matters where taxpayers often feel that they don't have anything that they can do about it. And in practice, I find that the frustration is entirely just Jackie, can you hear me?
Yes, I can hear you.
Yeah, I think we've lost my video for some reason and the slides again, but I'll put them up. Let's see if we can start the video again. There we go. Apologies for that, colleagues. The position on, let me just get the slides back. The position is that there is very little to be done from the taxpayer's perspective other than one of three things. The first is to go through the complaints system, and then after that to go through the tax ombud. But very often, these issues are much more pressing and urgent, considering that SARS can, within a matter of 10 days, take an order or judgment against the taxpayer who it demands a payment from and who's not paying. And very often there's an urgent requirement for a tax clearance certificate due to impending financial loss due to a taxpayer, for example, not being able to bid for certain contracts or to be able to enter into certain agreements or any other reason, have a bank account with certain banks or credit line. Often also banks require tax clearance certificates for. And this is a very real issue because there's also no prescribed process within which to submit a suspension application. As far as I'm concerned, the taxpayer is entirely within its rights to submit a suspension application via email. But then, of course, those applications do not get recorded immediately, meaning that SARS will continue to show the taxpayer is non-compliant. And as I said, these matters are often much more urgent than going through a complaints process with SARS and dealing with a tax ombud. The only recourse then in matters such as this would be High Court action. Take the matter on review and to go to the High Court to ask for the necessary relief through a declaratory order. But in practice, I know that is extremely dramatic. It is, of course, a costly matter. So, unfortunately, in smaller matters, one will have to set up and try and see to what extent one can spur SARS officials into action. But theoretically, the only real relief in an urgent matter, and one then that is significant enough, is to go to the High Court for relief. And of course, the costs in such a matter, if the taxpayer is successful and justified in approaching the court, can be recovered back from SARS through an appropriate cost order being made. But that, as far as I'm concerned, is the only relief possible. Yeah.
Albertus, and a listener asked, if a taxpayer decides to pay now and argue later, will the amount be paid back if the dispute is successful?
So, absolutely. And that is, I have two questions that I get often on that. The first is, I don't want to pay because SARS won't pay me back. And the second is, am I not admitting guilt in some way or form by paying now and arguing the case later? And both of those questions, I find in practice, as well as in theory, works in favor of the taxpayer. I know we've had a problem in this country with VAT refunds under the previous commissioner's reign. That is, in my experience at least, no longer such a big problem. If tax disputes are won, in my experience, yes, in some cases, of course, there is a bit of a delay, but in all cases, ultimately, the tax gets paid, gets refunded, gets paid back. So that is the first point. The second point am I admitting guilt by not submitting such a suspension application and paying the amount of tax now and arguing later? No, you're not. All you're doing is complying with your legal obligations in terms of the Tax Administration Act that requires you to make payment now and argue later. So again, by no stretch of the imagination can it be seen as an admission of guilt, and nor is it in practice even treated in that manner by any parties involved that I've experienced, at least. Jackie, do you want to continue?
I think we can move on to the next slide if you're happy, Albertus.
Okay, excellent. Colleagues, we said to one another at the beginning that in dealing with disputes and additional assessments, you have the option to request reasons. It's not always necessary to request reasons, but the option is there to request reasons. It can never prejudice a taxpayer. It's for that reason why I always encourage taxpayers, and I'll practice it standard practice, to always request reasons for an assessment. It is so that you stretch the process out a little longer as a result, of course, but it may be so that the process is then slightly more expensive for taxpayers because there is this additional step that is being taken in the dispute. But when one looks to a litigation strategy, that is, of course, again, what we're busy with right from the start, is we're anticipating a matter that may ultimately, hopefully not, but very possibly will end up in a litigious environment. And if that is so, we need to be clever about things. We need to have a strategy in place, and we need to anticipate SARS's arguments and deal with them from the start. And it's for that reason, in anticipating SARS's arguments, that we ask SARS for their arguments. And it is, of course, entirely inappropriate not to ask reasons, simply jumping to an objection, thinking that we understand the bases for the assessment having been raised. Very often, these assessments are being issued with the taxpayer having no clue whatsoever why the assessment was issued, or one guessing at the reasons for the assessment having been issued. That is extremely dangerous. And it also, of course, robs the taxpayer of an opportunity to deal with a dispute in the objection phase already. Flying blind in an objection can never work. The second reason why strategically it's important is that SARS must give reasons for an assessment which is binding on SARS for the rest of the process. SARS has been kept to those reasons for the assessment. In other words, those reasons are the only ones that we need to address as part of the objection and the appeal process. For example, SARS can't raise the issue of an assessed loss being ring-fenced later if SARS is refusing to recognize an assessed loss initially on the principle of the taxpayer ostensibly not trading. And it's for that reason why SARS giving reasons can only prejudice SARS in this process, can only be to the advantage of the taxpayer. You cannot lose out by requesting reasons. You can only win as a taxpayer. And therefore, the approach should be to always, if possible, and if still in time, as I'm sure all of us will be after today, with these things, checking our assessments regularly, the approach is always to, within 30 business days from receiving an assessment, to request reasons for that assessment. And I'd encourage tax practitioners and taxpayers alike here to be creative in requesting reasons. Is if SARS is saying, well, if an assessment shows that a deduction has been disallowed, is to ask SARS to say, on what basis are you disallowing the deduction? Please identify the relevant provision of the Act, the relevant requirement in the provision of the Act, and the facts that you've identified on which you believe that provision of that or that requirement of that provision of the Act has not been complied with, is to understand exactly what the issue in question is. Is it because SARS has not received an invoice? Is it because SARS is considering a taxpayer not to be trading? Or is it because an expense is viewed as capital nature? And to understand why that is the case. If SARS comes back with half-baked reasons or insufficient reasons, a taxpayer again has a recourse. All these problems are addressed in the rules. There's a Rule 52 that says that if SARS does not provide sufficient reasons, the taxpayer can go to the tax court to force SARS to provide better reasons. So one has that ability to force SARS to either give reasons or give better reasons if the request hasn't been adequately dealt with. The only instance where SARS can lawfully not provide reasons is if it has already provided reasons and it states that to the taxpayer within 30 days of receiving a reasons request. So, for example, it is often the case that after a lengthy and detailed audit, with an audit findings letter and a finalization of audit letter, an assessment is issued. It may be that what the taxpayer is requesting in the form of reasons would already have been addressed in the audit correspondence. And if that is the case, then SARS can respond to the reasons request, telling the taxpayer, I think I've already addressed this in paragraph 2 and 10 and 11 of the audit finalization letter, for example. And in that case, the taxpayer is then put back into the position where it consider whether it agrees that it has the reasons that it's requested. If not, it has recourse under this Rule 52 to force SARS to provide better reasons, alternatively to reconsider and perhaps to say, well, actually, yes, I do understand. I've already been alerted to these facts. meaning that the taxpayer then goes on to the next step in the process, which is to object against the assessment. And it has the same 80-day period still within which to do so from when receiving a SARS's response to the reasons request, whether to provide reasons or to point out to the taxpayer that perhaps reasons have already been provided.
Albertus, we have a question here.
Yes.
It's a bit of a long one. If a taxpayer received an additional assessment which referred the taxpayer to a letter containing the reasons for the additional assessment, but the taxpayer never received such a letter, and the time for requesting the reasons has lapsed, can a taxpayer invoke section 73(1) of the TAR that says that we can request a copy certified by SARS of the recorded particulars of an assessment or decision referred to in section 104 relating to the taxpayer? This section has no time limit.
So I think that a taxpayer would be able to request it. It doesn't need to be under section 73. It's to simply say, you've apparently sent me a letter and I've not received it. Please send it again. So I think a taxpayer is entitled to request it. That being the case, nowhere does it say that this suspends the time periods under the rules. So I would caution such an approach to be taken and to then disregard the prescribed time periods of the dispute process. If the taxpayer is late to request the reasons on account of not having received a letter from SARS, the rules unfortunately are very clear. The reasons must be requested within 30 days or the extended period allowed by SARS under that Rule 6.7 that we've discussed earlier. That is regardless of having received a letter or not. Very often we see that exactly in such cases, a letter would have been sent separately. There's that little description sometimes in an assessment that says refer to letter. And no one ever sees that letter, and I myself skeptically doubt whether such letters very often are being issued. Of course, I've seen some of them, but I think in many cases, simply there is no such letter. That does not mean that the taxpayer has a right to request that letter if there is no such a letter necessarily, especially in a manner that would suspend the prescribed time periods. The prescribed time periods still apply, and it's very important to observe this. Otherwise, one is kicked out of the process on formalistic principles and points linked to the time periods prescribed. It is that you have 30 days within which to request reasons. If you are late to request reasons, one has 80 days within which to object from the date of the assessment unless one gets an extension for the reasons request. Yes, in the meantime, you can request that letter from SARS that apparently has been issued and that has not been delivered, but it does not suspend the time periods prescribed under the dispute resolution rules, as fair or unfair as that may seem. The principle, however, is very clear. Alex, so if we move beyond the reasons request step then in the dispute process, the next step is the objection. And here we'll see in Rule 7.1a and b, the 80-day period being allowed, considering either whether the taxpayer has received reasons, alternatively, if jumping straight into the objection stage, follow an assessment, which, as I mentioned earlier, is not being encouraged. The taxpayer must then lodge an objection, and I think what we also see very often is taxpayers issuing assessments that are either invalid on account of not complying with the 5 requirements in Rule 7.2, alternatively SARS alleging an objection to be invalid. Now, let's consider briefly what a valid assessment, valid objection at least, involves. And those requirements are set out in Rule 7.2, and let's look at the less controversial ones first. Say that you must complete the prescribed form in full, and that's the form on e-filing, that notice of objection form. Let's have a look at Rule 7.2c. It says that if e-filing is not used, you must in your objection specify an address. As mentioned, I think that nowadays everything is on e-filing. In fact, I'm not aware of any objections that you can file without e-filing nowadays. D, sign the prescribed form in full. That also is automatically done through e-filing. And at E, within the 80-day period, submit the completed form to the address specified either in the assessment or to the address under Rule 2. We dealt with Rule 2 earlier, objections submitted via e-filing. The substantive requirement of what needs to be in an objection is in Rule 7.2b. Firstly, and unfortunately, these forms are set out in such a manner that it allows compliance and allows a valid objection to be submitted. I mentioned 7.2b because very often we amplify our grounds of objection in a letter to SARS that we attach to these forms. It's important to ensure that the form is correctly completed, but also that the letter speaks to the substantive requirements in Rule 7.2b. The first is to specify the part or specific amount of the objection of the disputed assessment objected to. Now that we have in those forms, to say that against source code, whatever the amount in the assessment currently is X, it should be Y. Importantly, Rule 7.2b is to specify the grounds of assessment. So it's not sufficient to say that the amount that you've disallowed is deductible. One should say why it is deductible. And again, I think we'll struggle to argue why something is deductible if we can't speak directly to why SARS has disallowed the deduction in the first case, because then we can't say why SARS' decision is wrong. So it's for that reason that the reasons are required. So it's to speak to the grounds of assessment that are incorrect, is to say that the amount is deductible because Section 11A applies and because the amount incurred involves this and it was in the production of income for the following reasons, for example. And thirdly, this is a new requirement. This was included in the new rules, or varied at least in the so-called new rules, promulgated in March last year. It is to say that no longer can we simply refer to supporting documents. Those documents that the taxpayer relies on to discharge the burden of proof, it must submit together with the objection. Now, previously, we were entitled to simply refer to documents that we intend to rely on. If the taxpayer relies on a document to discharge the burden of proof, which it has, it needs to attach those documents to the objection in order for the objection to be valid, so that SARS has those documents, has access to the taxpayer's proof, and can evaluate the objection on that basis. We've dealt with the importance of the 80-day period. I'm not going to stress it again. Let's deal briefly with late objections. If an objection is late, a taxpayer can advance either reasonable grounds, which is a lesser burden, for up to 30 days of lateness. After 30 days, the taxpayer has to advance exceptional grounds for why the objection is submitted late. And again, if SARS does not accept this reason for lateness, the taxpayer has the ability to object against that decision of SARS. So that's important. What would reasonable grounds involve for a late objection? I can tell you, colleagues, that a taxpayer not communicating or not having been aware of an assessment being issued is not considered reasonable ground. And there is precedent that backs that up. It means that tax practitioners are actually quite exposed, if not actively monitoring assessments and ensuring that disputes, if needed, are timely submitted. It is a very dangerous ground for negligence professionally for tax practitioners, I believe, to ensure that these things are properly administered. In our practice, at least, we have for our compliance book, we have 2 dedicated officials who go through the whole of the e-filing profile daily to ensure that any assessment issued is communicated and is picked up on. Just to give you an example. Reasonable grounds advanced would, as I said, be lesser grounds to explain why the relevant objection is being submitted late. If it's more than 30 days late, one needs to advance exceptional grounds. Now, again, exceptional grounds here aren't exactly defined, but SARS has communicated its interpretation of exceptional grounds, which seems rather fair to me, and they've linked it to the exceptional grounds listed in relation to penalty remission requests. So if you're late in meeting a tax obligation and you have exceptional grounds, then those penalties can be remitted. That phrase, exceptional grounds, exists in that section 218. It's not directly linked to the dispute resolution rules, although it is curious that again we have this test, exceptional grounds, and SARS itself considers section 218 therefore as instructive of what we should be considering as exceptional grounds. And perhaps to list some of these exceptional grounds, which I'm sure you're aware of, it relates to natural disaster, civil unrest, a pandemic, etc. So these are extremely serious matters that would have given rise to a taxpayer missing the 30-day after the 80-day deadline to submit an objection. So again, perhaps just to re-emphasize the importance of meeting these deadlines and monitoring them actively. So I said the consequence of not meeting these deadlines is very unfortunate, but it is that the taxpayer no longer has any recourse whatsoever in disputing that particular assessment, as fair or unfair as that may seem.
Albertus, what is the case where an estimated VAT assessment has been raised by SARS and e-filing does not allow you to object on the basis of prescription?
So this is one of those cases where that we've discussed earlier, where e-filing does not allow you to submit an objection. Of course, prescription is inapplicable in these cases to the taxpayer, because SARS has raised an assessment and the taxpayer has, regardless of how old that or the previous assessment is, the taxpayer has 30 days within which, after that assessment, to either request reasons or 80 days within which to submit an objection, regardless of whether the previous assessment would have prescribed or not. So if e-filing does not allow one to object, the recommendation, as I mentioned earlier, is again to use every other possible avenue to lodge the dispute. It is to write to SARS on email, if you have a SARS official involved, to write to them, and again to lodge the objection manually through a SARS appointment. But to demonstrate and to tell everyone in that letter, when you're submitting that objection, is to say that I've attempted to lodge an objection through e-filing, which is the prescribed avenue. I've been unable to do so because e-filing does not provide for a link in which to upload this objection. As a result, I have no other choice but to submit this objection through an alternative avenue. I am doing so via email to the general email address. I'm doing so via email to a SARS official, and I'm doing so at an appointment. I cannot think that anyone can say, but you've not follow the prescribed avenue, if the prescribed avenue in those cases then is not available to you. But I think what's very important is to recognize what the correct process is in the letter, to state that you're unable to meet that prescribed process, and therefore to indicate what alternative steps you've taken in a bid to have the objection submitted and to have it receive attention. Colleagues, we move on to Rule 8. So under Rule 6, we've asked for reasons from SARS for the assessment. We've then, under Rule 7, objected to the assessment based on those reasons. SARS, as we mentioned, can come back in one of three manners. It can either allow the objection, disallow it, or ask for further information. Perhaps if I can pause here and interrupt myself, there is, of course, a fourth potential outcome. And let's perhaps go back to the Rule 7.2 matter. It is so, and we've seen this very often too, that SARS says that the objection is invalid because the taxpayer, because the expense in question that's been disallowed has been incurred in capital nature, and therefore the objection is invalid. Some sort of a reason that one has there that's not in Rule 7.2a to e. And it is the fact that SARS can only deem an objection as invalid if it does not meet one of the requirements under Rule 7.2a to e. We've seen often that SARS issues notices of invalid objection on account of reasons or an apparent lack in an objection of matters other than these requirements in A to E. And that's simply not allowed. What is the correct process after that? I've seen taxpayers objecting and objecting and objecting and objecting, and each time an invalid objection is being issued, very often asking for further information, ironically, in those invalid objection notices. And that is wrong. If there is a procedural misstep in the dispute resolution rules, one shouldn't entertain it. One should call SARS on it through the appropriate mechanism in these rules. And again, I cannot stress this enough. Very often, by entertaining a misstep on SARS's account, an unlawful following of the process, the taxpayer itself goes down a rabbit hole, meaning its own actions are also unlawful, meaning that in time, it is placed in a position where there is no legal remedy available to it any longer under the rules. So it is very important that where there is a misstep procedurally by SARS, the taxpayer doesn't simply follow the SARS route that is apparently being prescribed by submitting new objections, but is to call SARS on the fact that there is a misstep and therefore that SARS needs to correct it. For that reason, again, there is in Rule 52.2b a mechanism for the taxpayer that's received an invalid objection notice to go to court and to say that SARS has treated my objection as invalid despite it meeting all of these requirements in Rule 7.2a to e. And if those requirements are met, SARS cannot simply issue a notice of invalid objection. I've also, colleagues, seen very often that following the receipt of a notice of invalid objection, a taxpayer appeals to that notice. That is not allowed. One cannot appeal a notice of invalid objection. You can only appeal an objection that has been disallowed. An invalid objection is one that doesn't meet the substantive requirements of Rule 7.2 and is one that is therefore simply not considered. It's not one that's been disallowed. It's one that SARS says, I'm not even going to look at it because it's invalid. Try again. And the taxpayer can then, of course, if it truly is invalid, submit a new objection within 20 days. But barring that, if an invalidity notice is received and it's unlawful, it shouldn't have been issued, taxpayers shouldn't be following the advice in that notice. SARS can also sometimes be wrong in interpreting these rules, and they are, unfortunately, quite often wrong in following the rules. It's important that taxpayers appreciate that. What happens if a taxpayer submits an appeal against a notice of invalid objection? Of course, you can only object to or appeal a disallowed objection. So let's take that as an example of how taxpayers or tax practitioners would then prejudice themselves and their clients. Suppose you submit an appeal after receiving a notice of invalid objection. After 30 days, SARS should have notified you whether they wanted to participate in ADR or not, and they don't. Now you follow up and you phone and you send emails and you eventually perhaps even issue a Rule 56 notice. And SARS comes back to you and say, well, we're not looking at your notice of appeal because it's been invalidly filed. There was a notice of invalid objection that's been issued. So you should have responded to that, either through having it set aside or to submit a new objection. If you now want to comply with that prescript to approach a court or to submit a new objection, you are woefully out of time, meaning that because of not following the correct process, the dispute itself is dead. It's been detrimentally wounded, and there's simply no recourse left for the taxpayer, as good a merit or argument it may even have in following that dispute, which is extremely unfortunate. But We are not going to fall into that trap any longer. We say that following having submitted an objection, SARS can either lawfully invalidate it, disallow it, allow it, or fourthly, it can request further supporting documents. Now, it's interesting here to watch the interplay with Rule 72B. What Rule 72B does is in Rule 72B3 is to say that the taxpayer needs to submit the documents that it relies on in discharging the burden of proof. What Rule 8 does is similar to a tax court process, really, is to say that SARS can say, okay, you've now given us your documents. We want to also ask for documents. Give us the following documents. And SARS has the ability to request those documents under Rule 8. Of course, what this rule does not allow is a fishing expedition. We must be very clear on this, that when SARS has issued an assessment, it has done so because of the provisions of Section 92 of the Tax Administration Act. Now, what does Section 92 tell us? It says that SARS may issue an additional assessment if it is satisfied that it is necessary to cure any prejudice to the fiscus. So SARS already in issuing an assessment needs to be satisfied of the correctness of the assessment. It cannot, after the fact, ask for information and go around in a fishing expedition type manner to obtain other information to consider whether its assessment position is correct, or to even see whether other potential bases for assessment can also be raised. It's not allowed to do so. It can simply request those documents which it believes is relevant also in vetting the dispute itself. Again, here we have certain prescribed time periods. SARS may only request further documents if it does so within 30 days. If not, SARS is out. It may not request those further documents. And the taxpayer must in turn then submit those documents within 30 days. It can, of course, request for an extension again, as usual with these rules, for up to 20 days to deliver those documents. Strategically, it may sometimes be, I think, wise not to keep SARS to the 30-day period within which to request documents. Let's take an example. I've submitted an objection on today, 28 August. 32 days later, SARS comes to me and says, Albertus, I need further documents from you. I think for me in those cases to say that I do not think that you can request further documents may in cases be unwise, because me being cooperative in that sense and giving further documents to SARS, especially if I have a very strong case, may work in my favor, because SARS may consider those documents and say, oh, actually, we see the point, we are allowing the objection. So I think, colleagues, it's important for us to distinguish between when it may be wise to perhaps provide an indulgence in these cases and when to strictly enforce these time periods. After SARS has received our documents, if they are in fact requesting them, or after SARS has considered our objection, which must be within 60 days, we are then given an outcome of objection. Two things that I want to stress here on the outcome of objection issue. SARS is not only required to give an outcome of the objection, it must also communicate the basis of the outcome. So let's read Rule 9.1 together. It says that SARS must notify the taxpayer of the allowance or disallowance of the objection and the basis thereof within a period of 60 days, or if supporting documents were requested within 45 days. In other words, it is not simply enough for SARS to say that the objection has been disallowed or it's been partially disallowed. SARS must also communicate the basis for the disallowance. Why is that necessary? It's really a reflection again of Rule 6, is to say just as a taxpayer needs reasons for an assessment to lodge an objection, so too the taxpayer must understand the basis for the disallowance of an objection in order to be able to appeal. So that makes sense. It's for a taxpayer to have information available to take an informed choice and an informed approach in moving to the next stage or step of the relevant process. SARS may then, the 60-day period, extended for 40 days or up to 45 days if exceptional circumstances exist as communicated by a senior SARS official. It cannot simply extend it and let the taxpayer know. It must base that decision on the complexity of the circumstances or other exceptional circumstances that may warrant such an extension. Often we see that after the 60-day period, we still haven't received an outcome of objection notice. And then we issue SARS with a Rule 56(1)A notice to say that you had 60 days, you've not complied with it. We are now giving you another 15 days before we're going to court to place you in default. Very often then you get these letters to say that we're giving ourselves a 45-day extension. That's not sufficient. That is very often simply to buy further time. The taxpayer is then entitled to say, I understand that you are intending to extend the period for deciding the objection under Rule 9.2, but that is premised on the basis that you have good reasons for doing so. The taxpayer is entitled to ask and request for the basis for that decision and why it is that it is not simply a case of SARS biding its time in reaching an outcome of the objection. I want to, before moving on to the appeal stage, mention one matter. We've said right at the beginning what matters can be objected to. Perhaps to go back to that slide. Here at the bottom, what you cannot object to, the third bullet. You cannot object to SARS failing to issue an assessment even after an objection has been allowed. Now, this may sound strange, but what happens often is that the dispute team within SARS do not speak to the assessor, meaning that the objection is allowed, but then the assessment is never issued. And I'm sure as many of you will have had that experience. What to do in that case? I've seen clients who tried to object again. You cannot object again. The assessment and the objection in relation to it has already been decided. So what is the recourse? When one looks to Section 106.3, which deals in lesser detail than Rule 8 with the objection process, in fact, simply says that there is an objection process. What Section 106, however, also does is to say that under the rule, SARS must in time consider, in prescribed time, consider an objection and, if allowed, issue an assessment. It means that the objection process, if successful for the taxpayer, has not concluded until the assessment is issued. So the correct process to follow there is, again, it's an obligation that is provided and that is placed on the Commissioner under the rules read with the relevant part of the Tax Administration Act that has not been complied with. So again, that is an obligation that should be called on and that the Commissioner should be alerted of through providing a notice to SARS under Rule 56, is to say that, Commissioner, following the outcome of the objection and the objection having been allowed, you are under an obligation under Section 106.3 to issue an assessment. You have not yet done so. I'm giving you 15 days within which to, unless following which the matter will proceed to the tax court if you do not meet that obligation. The final matter and the final step of the dispute resolution process that I think most of us will be dealing with is the appeal stage. Now, again, what I want to stress here is that the appeal is not to SARS. Now, this is often a misconception that I find clients and other tax practitioners have, is that following an objection, this is just a second SARS tier of the dispute, which is to say that I'm now appealing to a different committee or SARS official. We live in a society, fortunately, governed by the rule of law, meaning that SARS is not the legislature. SARS is not the judiciary. SARS is the executive. it administers the tax acts, but it is simply not in a position to make legislation or to determine the final outcome of a dispute. And that is where the appeal process comes in. The objection process is first to allow the taxpayer to go to the administrator, in this case SARS, and say, there is a dispute, let's see if we can sort it out. If the objection stage is unsuccessful, at that stage, the parties proceed to have the matter finalized in an independent forum. As I said, that is allowed for theoretically. In practice, that's not often the case, through mediation, alternatively through litigation in the tax board or the tax court. The ADR process we'll start off with. If a taxpayer submits a notice of appeal, it can, in that notice, elect either to refer the matter to ADR or to refer the matter for litigation. If the matter is referred to ADR, it is not to say that there must be an ADR meeting. There is mediation going to take place. What it says is that the taxpayer would prefer the matter to be referred to ADR, to mediation. And why I use that word, which is purposefully used, is to say that the ADR process only takes place if both the taxpayer and SARS agrees for the ADR process to take place. So if the matter is on the election of the taxpayer, potentially referred to ADR, SARS must then, within 30 days after that, tell the taxpayer whether it is amenable to follow the ADR process or not. And this is something that I see in practice also, where disputes often get stuck. As a notice of appeal gets issued or is issued by a taxpayer, the taxpayer elects for the ADR process to take place, and one never hears from SARS ever again. And so months and months can pass. The way to do it, again, is that there is an obligation linked to a time period that is placed on SARS in terms of the rules, a 30-day period to respond whether it too agrees for ADR to take place. If it hasn't responded within 30 days, it has not complied with an obligation, meaning again, a notice under Rule 56(1)A can be issued to spur SARS on and to alert it of the fact that it is in default, and it has 15 business days within which to remedy said default. Of course, then, when an ADR meeting takes place, there's a 90-day period within which the ADR proceedings need to be concluded. And colleagues, I know that a number of you may be intimidated or not reluctant to enter into discussions with SARS. It really is not an intimidating experience at all. It really involves a taxpayer sitting with one or two tax officials, who are also just human beings, in an unintimidating, neutral environment, and talking about the matter and see whether the parties can find one another through discussing the matter in a collegial way, or to exchange further information or exchange further documents. It is also so that the ADR process takes place on a without prejudice basis, meaning that anything that is said in that meeting is confidential and may not later be used against the taxpayer if the matter proceeds further to a hearing of sorts. I can mention at this stage that I've also seen rather odd letters sometimes being issued by SARS, saying that they do not think an ADR meeting is necessary because they've considered the facts in the taxpayer submissions, and they do not believe essentially that the taxpayer has a case. So the taxpayer is requested to kindly withdraw his appeal. And that's nonsense. I mean, SARS cannot instruct a taxpayer to withdraw an appeal. So I want to be sure that taxpayers understand that they needn't heed that instruction. They can absolutely take cognizance of SARS's view on the matter, but if they strongly believe in their case, and SARS is disinterested then to meet to try and mediate the matter, taxpayers have further recourse. They needn't say that I must withdraw an appeal because SARS says so. The next avenue is then, if ADR proceedings break down or are unsuccessful, is for the taxpayer to litigate the matter, is to either itself or through a legal practitioner approach the tax board or the tax court. And that brings me to the alternative after ADR or instead of ADR, is that the taxpayer has the ability to litigate a matter. And we have two potential forums in which that takes place.
Albertus, can I interrupt you just with two quick questions before you move on that are relevant to ADR? Based on your experience, does ADR usually assist in resolving the dispute? Do you think it is more beneficial than written correspondence?
Look, the ADR process doesn't provide for correspondence. And I've often seen that the SARS auditors, using the ADR process as an excuse, asked for further information and documents to be submitted, very often completely irrelevant to the dispute in process, meaning that it is yet another excuse to engage in a fishing expedition, either to raise a further assessment or to gather information which is not allowed, to have an alternative basis for the assessment having been issued. So I would discourage ADR by correspondence. Insofar as it relates to the meeting, very often the process, I think, or the success or otherwise thereof, depends on the attitudes of the individuals involved and whether there is a real desire for the matter to be resolved through ADR. So if one is friendly and collegial and frank in those discussions, and the same is the case for the SARS officials involved, the ADR process very often can yield favorable results for a taxpayer. So that is absolutely possible. It is unfortunately so that very often SARS auditors or officials arrive at that meeting with the attitude of simply explaining to the taxpayer why they're wrong. Now, if both parties arrive at the meeting fully convinced and entrenched already in their own views and their own positions, there's no real sense in trying to talk. And one very often 5-10 minutes into those meetings get a sense of where it's going to go, and it's best then to say that, look, it's very apparent that we're not going to convince one another of anything. Let's call it a day and leave the ADR meeting. I have had very pleasant experiences with SARS officials who really try and see whether the matter can be resolved either through litigation. Of course, very often you also have SARS officials on the other side who are less than pleasant, and sometimes I must admit I myself am probably at fault in these meetings for my own demeanor in those cases. Then, of course, the matter is litigated. The reason for that is simply that the matter is one that needs to be addressed. The taxpayer clearly has merits, and if it's not going to be resolved through ADR, through SARS officials being disinterested to discuss the matter, the only avenue, unfortunate as it is, that is left to a taxpayer is to litigate the matter, and we shouldn't be shying away from that, I believe. The other reason why ADR is also beneficial is that, of course, ADR can be resolved in one of two ways. Either through the taxpayer or SARS convincing one another to a certain extent or otherwise of the merits of the matter. Alternatively, if they still don't see eye to eye on the merits, you can also cut a deal with SARS. It's to settle the matter. To say that, look, we're clearly not going to agree on whether the amount involved and that we've expended and claimed as deduction is capital in nature or not. So, in order to try and finalize the matter in an amicable manner and without going to court and incurring costs and trouble and the rest of it, let's try and settle the matter. And that is specifically provided for both in the ADR process as well as outside of the ADR process. But Rule 25 specifically provides for, I think it's Rule 24, specifically provides for a settlement to be reached. In that case, the taxpayer or SARS might propose and say, what if we split the difference? We think there are merits in capital nature not being the case, and you think it is. Would SARS be amenable for half the amount to be allowed as a deduction, half disallowed? And very often I find that our SARS colleagues are amenable to settle these matters on that basis, or a 60-40 basis, or whatever and to have the matter resolved in that manner. So this is an alternative litigation. The purpose for the ADR process is not for the parties to gather information. It's not to grandstand. It is simply to try and avoid litigation. That's the purpose of it. But often ADR is also going to be inappropriate. It is often the case, for example, I'm not sure, colleagues, whether a number of you have dealt with these ETI schemes, so-called. We've seen a number of them in practice, and I have a number of clients engaged in those disputes. It is often the case that in those matters, you know that SARS has already taken a position in relation to this type of, or the set of facts, meaning that further discussing the matter will not yield any result. In those matters, ADR is inappropriate because everyone knows that the result following an ADR meeting, which just takes further time and involves further costs in employing tax practitioners, will not have any result. In those limited cases, one would litigate the matter directly and opt to go directly to the tax court or the tax board. The tax court process at the moment is the prescribed forum for all tax disputes. The only exception is that the parties may elect to go to the tax board as an alternative. So it's not so that you must go to the tax board. You can elect to go to the tax board, provided that the amount in dispute is less than R1 million, is the prescribed threshold at the moment. In those cases, one can go to the tax board. And of course, in that forum, the taxpayer can appear on itself, on his or her own, or with the help of a tax practitioner, which needn't be a legal practitioner themselves. And it is, even though a forum that is similar to a court environment, it is a much less formal environment compared to what one finds in the tax court. For example, one doesn't need to wear a robe in the tax board, and those hearings typically take place in a court-like room in one of these SARS buildings and offices in and around the country. Insofar as the tax court process involves, that is, of course, a much more formal and involved process. It involves, like high court matters, the exchange of pleadings, a discovery, witness statements, the filings of heads of arguments, and the rest. There is a proposed amendment now in the Tax Administration Laws Amendment Bill that deals with the tax board and the tax court. And the proposal is that the tax board will be the prescribed forum for all matters less than R1 million. In other words, there's no longer the election to go to the tax board. It is the mandatory first forum for litigation for all matters under R1 million. The other potential or proposed adjustment, or amendment rather, I should say, in the draft Tax Administration Laws Amendment Bill that we've received, what's it now, about 3 weeks ago, tomorrow, relates to the lateness in filing an appeal. As we had with the objection, you are also able to file an appeal late. That is up to 21 days, provided that it is reasonable grounds that caused the delay in filing the appeal. So that's beyond the 30-day period within which to file. If exceptional grounds exist, one can file an appeal up to 45 days late. But if it is more than 45 days late, a taxpayer can approach the tax court for condonation. But if the appeal is then filed more than 120 days late, not even the tax court can condone the late filing of that appeal, meaning again that the taxpayer would in those cases not be able to proceed with the matter at all, which is rather unfortunate.
Albertus, can SARS also choose to take the matter to litigation if they fail to reach an agreement with the taxpayer during the ADR process?
Absolutely. So it can happen in one of two manners. The first is that during ADR, SARS says, look, we can see that we're not going to beat one another. Let's litigate the matters. They can elect for ADR proceedings to be suspended and for the matter to proceed to litigation. So SARS can also elect out of the ADR process. And that is whether the ADR process has commenced or after 30 days of receiving an appeal indicating that the taxpayer wants to pursue ADR, SARS can say, look, we're not interested in discussing the matter. we're not interested in following ADR. You need to litigate the matter if you want it to be resolved. I've, in my practice, never seen that take place, but the rules are very clear that SARS needn't always engage in ADR matters. It can opt to litigate the matter directly, or for a taxpayer at least to litigate the matter. Colleagues, we're moving on to our last slide, and I want to finish this in 5 minutes so that we have time for those questions left that we can finish in time, which is 12:30, and that's in a little more than 10 minutes. I want to stress the importance of these rules and not being misled potentially through what we see in cases where SARS communicates an outcome to a potential step. I've seen, for example, that SARS has responded to a request for reasons by saying your request for reasons has been declined. Look, SARS cannot decline a request for reasons. It can either give reasons or say that I've already given you reasons, you need to object within 80 days. It cannot decline a request. So it's important to understand that. The second is these notices of invalid objection being issued on unlawful bases. We've discussed that. I've also seen SARS saying that we've declined your appeal. Understanding the process and that the appeal is to a third-party forum, an independent forum such as a court or arbitration mediation, at least with an independent facilitator, appeal is not something that you do to SARS. It is beyond SARS at that stage. So an appeal cannot be declined by SARS. We've discussed the instances where SARS has informed the taxpayer that it should rather withdraw its appeal. Again, that's not a valid request to make. Finally, there are cases where we've seen SARS withdraw an outcome of an objection. Now, it is so that under Section 9 of the Tax Administration Act, SARS can withdraw certain of its decisions or communications to a taxpayer, but it cannot withdraw anything that culminates in an assessment. And the outcome of an objection culminates in an assessment being issued. So once an outcome of objection has been issued, particularly one allowing an objection, SARS cannot invoke Section 9 to withdraw an outcome of an objection. As I said, we've also seen strange taxpayer and tax practitioner behavior. And we're also not, from a non-SARS perspective, innocent in dealing with these processes. As taxpayers often. And that is, I've often seen an objection being disallowed, and then the practitioner complains to me that SARS has not considered their second objection that they've submitted. You cannot submit an objection after an objection has been disallowed. The objection has been disallowed. The next step in the process is to submit an appeal. You cannot request reasons after an objection has been allowed or disallowed. Similarly, you should not object to an assessment after you've submitted the request for reasons that SARS hasn't responded to. Rather, the next step after submitting a request for reasons would be to force SARS to respond to that request. And I think where we have these anomalies, the correct approach is always to go back to the last valid step in the process. Where we have these processes take place and these steps that are clearly unconventional and, on the face of it at least, not in keeping with the dispute resolution rules. How do we deal with it? The approach is always to go back in the process, see what was the previous step and perhaps the previous step before then, is to go back and to identify the last correct valid step and to see after that what should have been the next step, what was the step that was taken, and how does one then address that misstep, be it through a court application or calling SARS on it, or to realize that this has created a different obligation perhaps for the taxpayer. Realizing also that it shouldn't be entertaining a misstep and reacting to it. So again, colleagues, very important, just to finalize before we get to the final questions. I think what is very important is to understand broadly two things today. The first is to observe the time periods prescribed. There simply aren't exceptions. The second is to understand that the process is clear in Rule 6 through to Rule 10. The first process following an assessment is to request reasons. The following step, following a request for reasons, is not to object, is to wait for the reasons. That is the next step. Or for SARS saying we're not going to give you reasons because we already have. The next step after that is to lodge an objection. After that, the next step is either invalidity notice, lawfully issued, a request for further information under Rule 8, an allowance of the objection hopefully, or a disallowance of the objection. In the cases where you have an invalid objection notice, consider whether it is correct. Otherwise, submit a new valid objection as provided for in Rule 7.5 and addressing the problems with the initial objection therein. If further information has been requested, respond to that information request. If the objection has been disallowed, lodge an appeal. That, in short, is the process that we should be following, and which I hope will assist that we do not prejudice clients or our own cases through dealing with matters with even the best merits possible, falling short or falling out of the process, being disallowed simply due to tax practitioners and taxpayers being oblivious and ignorant of the correct process and the prescribed rules to follow. Jackie, do we have any further questions just before we wrap up?
I think there are a few, Albertus. The first is, there is a proposed amendment to bring the ADR process in at the objection phase. How do you think that this will impact the process? And do you think that we can anticipate an amendment to the rules?
Yeah, so one of the suggestions in the Draft Tax Administration Laws Amendment Bill now is to introduce a further ADR process, and is to bring the ADR process forward to say that before an objection is lodged, there can be an ADR discussion. In other words, that the parties can meet to discuss matters to see whether it is possible, sorry, not before the objection stage, after the objection stage, of course, is once an objection is submitted, is to say that we can resolve the objection through an ADR process. That ADR process being proposed as an amendment to the Tax Administration Act is not provided for currently in the rules. So if it is going to become law, as we anticipate it to be, then the rules will change. So we will see new tax court rules being promulgated then within the next few months. That's the first. The second is, I think taxpayers will need to consider whether to entertain that process. And you can only talk so much. I would think that only in the most exceptional cases would one entertain an ADR process as part of both the objection and the appeal case. The majority of cases, I think one would want to entertain the ADR process as soon as it becomes evident what the issues in dispute are. That may be after the objection stage. And if so, I think it's inappropriate in most cases to do an ADR discussion again after the appeal's been submitted. Alternatively, if the parties are still engaged in many disputes and the relevant dispute involves a number of factors, then ADR may potentially be only appropriate when those issues have been limited, which will be the case presumably after an appeal has been submitted.
Albertus, and one more. What, in your opinion, is considered adequate security by SARS for purposes of a request for suspension of payment?
Look, it depends whether security is even required. It may be that the tax amount in dispute is rather small, let's say less than 100,000 Rand, and the taxpayer is worth 5 million Rand or 10 million Rand or 100 million Rand. And it owns a number of illiquid assets, such as property, for example. In those cases, security simply is not appropriate. It's not necessary to give for security arrangements to be put in place. So in our suspension applications, which I assume this refers to, we say that the taxpayer is happy to discuss security and the following measures could potentially be used. But it's to not tender security necessarily, because it's not always going to be tender security definitively, because it's not always going to be appropriate. But adequate security involves security for at least the amount in dispute, together with interest and penalties that may have arisen. It would be interest that, or security, not only of that value, but also in a nature that SARS has the ability to to act against and to exercise its rights in terms of the security if the tax debt needs to be called upon. Ultimately, it is therefore SARS's benefit to say that you needn't pay now, but I want to know that the money is not going to disappear, and for that reason, I want certain assurances from you or security put in place to ensure that if you run away with your money, that I can still action the security to know that the tax debt will be recovered.
Then, colleagues, on behalf of AJM and Albertus and myself, I just want to thank you for joining us. We hope that you enjoyed the webinar and that you took something valuable from it apart from your CPD points. Otherwise, I think, Albertus, if you are done, I think that concludes our webinar. And there has been a question of whether there will be more of these dispute webinars. Our colleagues have said that it has been very helpful.
Fantastic.